Number 5, the people of the state of New York versus Michael Thomas. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court, Jean Joyce for Appellant, Brooklyn District Attorney's Office. Your Honor, I'd like to request 2 minutes for rebuttal, if I may.
You may.
Your Honor, the people are asking this Court to set...
Counsel, I'm a little confused by your rule, because it appears to me that your rule essentially measures sequentiality from the time of conviction, because your position is the sentence doesn't really matter. What matters is whether or not the defendant has been chastened by the prior conviction, right? And I'm having difficulty with that particular approach, because if that's what the legislature meant, once you have a conviction, doesn't matter when the sentence occurs, it's just the conviction, it's just that they've committed that crime, they would have said so, and they've had opportunities to do that on several occasions, and they haven't.
So our rule is that the original sentencing date should control. Not just the conviction date, but the original sentencing date.
If a sentence is vacated, there's
That's
no
correct.
original sentence, right?
Well,
There's only one sentence, correct?
there is a sentence, an original sentence, and then there may be, in a variety of circumstances, a resentence, which is an alteration of...
But if a sentence is
sentence.
vacated and another sentence is entered, do you
Right.
agree there's only one sentence?
I agree there is one original sentence and there may be a resentence, that the original sentence may be vacated, that's true. In this case, the sentence was vacated because it had an illegality. However, we're talking about the date of that original sentence as being the triggering date for the rule. And the reason for that is the legislative intent, which can really only be given effect by use of that original sentence.
Have you seen anything in the legislative history? I've looked and I haven't found anything that bears on the question of why the legislature picked, instead of the date of conviction, the date of sentence, and required that the sentence be issued before the conviction for the crime to which the enhancement is being applied. I mean, did you see any legislative discussion of that or anything?
Conviction versus sentence?
Yeah.
Well, Morse talks about the idea of chastening, which is an important part of the statutory intent. In other words, a defendant has to be given essentially notice of the conviction and that it's got some consequences. That sentence is imposed, the defendant hears what the consequence will be, and then has the opportunity to become chastened by fulfilling his sentence and staying out of trouble for the 10-year period.
So it's that pronouncement, just like
Correct.
we talked about in Sparber things, the pronouncement of sentence, right?
That is an important part of the process, of the intent of the legislature, that
So you're essentially arguing to expand the Sparber analysis to cover this situation?
yes, I'm saying that even if a sentence has been vacated because of some irregularity, it may be it may require a plenary proceeding.
Two things. First, it seems that the appellate divisions, in my review of the cases, since about 94, have pretty much ruled the way the Second Department did in Escalade. All 4 appellate divisions have seemed to consistently ruled in this fashion. Now, interestingly, when they have ruled in this fashion, sometimes the look-back period helps the defendant, sometimes it helps the people. Would you argue that if this rule went into effect, that the people could ask for a resentencing in certain circumstances to bring someone within a look-back period?
Well, first, I would say that with respect to the Second Department and the underlying cases and the appellate divisions, I think some of those are based on really a too broad reading of Bell, of this court's decision in Bell.
Okay, but it's been since '94 that they've been ruling in this way. So, and I didn't find any appellate division cases that really support your point of view. The only thing that supports your point of view is Sparber, and that's pretty much been seen as a ministerial correction by the case law in this court, though I can't say definitively it is, because I don't think definitively it is. But that's my personal view of it. So that's why I'm asking you this question, because there seems to be a very, very big difference between a resentencing and what referencing based on an illegality and what we characterize as an original sentence. In other words, there's no need to make a fetish out of the phrase original sentence. What matters in sentencing is when was the legal sentence passed for enhancement purposes. And enhancement clearly is much more than an administrative correction or a pronouncement. It's much more than that. It has serious consequences for all the parties involved.
Right, and the problem with using the resentencing date is it will not affect the legislative intent that an ever receding conviction, say, in this case, the conviction occurred in 1989. The underlying conviction, he was resentenced in 2009.
But that isn't what the case law shows. What the case law shows is sometimes it helps the people. They get a case within the look-back period. There are some appellate division cases that say that, and then there are some appellate division cases that benefit the defendant. In point of fact, this defendant may be benefited by it, but I don't think you can fairly say that this will affect that this is a one-sided ruling one way or the other. It seems to me that if we say that the sentence has to be a legal sentence to be considered for enhancement purposes, that could affect either party in the look-back.
Sure. Whatever rule you come up with, it's going to affect both sides. And our position is that what will better affect the legislative intent is the original sentencing date, because the defendant is chastened, whereas on resentencing,
Well-
20 years
By
later,
the
he's
same
not.
token, it defeats the legislative intent of giving the defendant.
I'm sorry?
It defeats the legislative ameliorative intent of the look-back rule. So it may be not in defendant's favor, but it's still against the legislative intent, isn't it? Both ways.
So using the original sentencing date will affect
No,
the-
if you don't use the original
Right.
sentencing date, you are going contrary to both provision, the legislative intent for both provisions.
I believe that's correct,
Whether it
yes.
helps or hurts one side or the other, it's still against the legislative intent.
That's our
So
position.
I want to go back to the beginning, Bell, all right? In Bell, we have the judgment, which is composed of the conviction and the sentence. And there, because the conviction is upset, you're basically upsetting the whole judgment. And instead of getting into all of these issues of are you vacating the sentence or modifying the sentence or resetting the sentence or just pronouncing, wouldn't a simpler rule and a clear-cut rule be that unless you have disturbed the entire judgment, then when that judgment became a judgment is what you control?
That's a great rule for me, unless you disturb the entire judgment.
Well, I'm
then-
not trying to do this to favor one side or the other.
Right.
I'm trying to have a clear, bright line rule.
It's a clear, bright line rule that in some circumstances will benefit particular defendants, and in other circumstances will benefit the people.
Correct.
It happens to be a rule that I would
Right.
agree with, that the
So what would be the effect of such a rule? Would that mean that if there was an error in sentence and you had to open up the judgment, that the conviction would then be vacated?
If you have an error in sentence,
Right.
then the sentence
If
can
you
be
say that
corrected.
the judgment, if you argue that the judgment has to be treated as a whole, and there's a bright line rule, conviction plus sentence is judgment, then if you vacate the sentence, you could conceivably be vacating the conviction. The people aren't arguing that, are they?
No. Judgment doesn't appear in the statutory
So if you're not
scheme.
arguing that, then you have to inherently stick with the position that conviction and sentence are two different things, and they're considered separately, right?
Well, on an original a judgment and original
Well,
sentence.
forget about the whole
They're-
original thing, let's leave that
together.
phraseology alive, because that's nowhere in the statute. Those are languages that have been imposed upon in our own analysis. But you can't separate, you're not arguing that those two are inseparable concepts.
No, what I'm saying is that once there's a valid conviction, that's a triggering date, along with the sentence that is imposed.
But
Here's the-
that's my problem. That's not what the legislature said. And the legislature has had an opportunity time and again to change the statute to focus on the conviction, which, as you rightly point out in your briefs, I'm not saying there's not something to the argument, that is, of course, when the individual has committed the unlawful act. If they do this again, they've not been chastened, and that's what the legislature is trying to get to. But the legislature could have made that linguistic change, and it has not. It's always focused on the sentence, and there is only one sentence.
Well, I think in Boyer, this court said that the original judgment controls, even though the sentence was in part illegal.
Well, Boyer is difficult for you, I think, isn't it? Because Boyer, the rationale in Boyer, at least as I read its holding, depends on the proposition that the term of imprisonment was not changed. And by, I think, necessary implication, had the term of imprisonment been changed, which is the case here, Boyer says the opposite result obtains.
I don't read Boyer quite that broadly. I think the point of Boyer was to say, look, in Lingle, the Court of Appeals said, we are not reopening all of these PRS cases to
The only
de
problem
novo
with
review.
Boyer is it says the date of the sentence is the original date on which the defendant received a lawful prison sentence. Here, the people admit that these sentences that we're discussing, the 1989 original youthful offender, were not lawful. You've conceded that. So the question is, can an unlawful sentence be used to enhance a lawful subsequent sentence? That's the question before us.
That's
Can something
correct.
that's unlawful enhance a lawful sentence?
Well, and I would say that it's the date of that sentence, not the inherent illegality.
Which-
of
and
the
the date
Thank
of
you,
the sentence-
counsel.
And the date of the sentence is essentially the conviction.
I'm sorry.
The date of the sentence is essentially the conviction.
Essentially, that's one way to look at it. Thank you.
Counsel? Counsel, will you speak to the legislative intent and the fact that if we, that your position that the date of resentence controls, perhaps there's a view that that does indeed undermine the legislative intent around sequentiality?
Yes, Your Honor. First, I want to introduce myself, Melissa Horlick, for Mr. Thomas. Good afternoon. The legislature was very clear in its language that the sentence must be imposed before commission of the present felony in order for it to qualify under the sequentiality provision.
But is there any statutory basis for distinguishing between a Sparber resentencing and other resentencings for the purpose of determining the date? For the purpose, we're talking about one purpose, the purpose of determining the date of the predicate sentence.
It develops from this court's case law in Boyer and Lingle, where the court has very clearly stated that in assessing whether or not the original sentencing...
But that's not statutory. That's this court. And I'll be the
Yes.
first one to admit that if you trace all the cases, they are not crystal clear as to, as to what the result is. Because I think if you look at Thompson and Estremera, they clarify in some ways Boyer and Acevedo and so on. So I'm asking you whether there's anything in the statute that dictates this distinction that has been drawn in some of the cases between the Sparber resentencings and other kinds of resentencing.
I don't think that there is anything in the statute, but I do disagree that the cases are not clear. Thompson was actually, I think, a very good case for me because Thompson's sentence was a legal sentence. And the court pointed out, I think 3 times in that decision, that when probation was violated and the defendant was resentenced to a term of imprisonment, that was not the analog to annulling a sentence. And the exact opposite occurred in this case. My clients' sentences were completely annulled and vacated because they were illegal.
Well, let's talk about Estremera that said that Barber is still a resentencing of an illegal sentence.
I think Estremera is mostly on point about the defendant's right to be present at that type of
But
proceeding.
that's how we derived the right to be present.
I think Estremera says that anytime the defendant is being sentenced, he has, of course, the right to be present to hear that sentence. In that case, the defendant had filed a motion, so he had every right to know how the court was going to impact and decide his sentence. I agree with Estremera that the defendant has the right to be present,
But
but
if Estremera was not an illegal sentence, then what's the point of resentencing?
the court in Sparber and Acevedo and in all of its decisions has rightfully characterized post-release supervision as a more technical procedural remedy akin to a misstatement or a clerical error. And the heart of the defendant's sentence is not implicated at a Sparber resentencing. The heart of the defendant's sentence on a post-release supervision case is legal.
Well, hasn't the legislature subsequent to Sparber and this line of cases actually spoken to clarify their position on these types of resentencing and in essence backstop the Court of Appeals opinions?
I'm sorry, can you repeat that?
Hasn't the legislature passed a subsequent law after Sparber saying that these Sparber resentencings in essence are valid?
If under certain conditions, yes, they will allow a certain sentence in a plea arrangement to remain if the district attorney's office agrees to that. But my client's situation is completely different from a Sparber resentencing. Going back to how we're here and why we're here, and when my client was just a 17-year-old indigent.
Also, going back to that, I mean, it seems as a policy matter and in view of Judge Stein's comments about, this court's role in determining this issue, your client, I think, ultimate goal is to be sentenced as a first-time offender and get rid of a persistent violent felony offender sentence, despite the fact that there are 3 prior robbery felonies on his rap sheet that he was sentenced for, convicted and originally sentenced for, before that persistent violent felony offender statute was imposed. How is that good policy? How does that in any way further the goal of the legislature?
I don't think I understand. I admit my client has a record, and he may benefit from some remedy that the court may or may not decide here today. But that's really besides the point.
Is it besides the point of a statute that was geared towards exactly addressing this type of recidivism?
The statute was very comprehensive in laying out a long list of criteria in order for any felony to qualify as a predicate felony. And it's an integrated system. So the legislature did not intend to punish every single person that commits another crime. It has to fit within the statute. And my client is only seeking to be sentenced in accordance with the law as it's been written and as it's been interpreted by this court.
Well, sentencing is also laid out in the statute as to what types of sentencing are included, and nowhere is the term resentencing included in the statute. So does that tell us anything?
I don't think so, because I think the legislature would have been hopeful that legal sentences were at issue, not illegal ones, and this goes back to why we're here. My client received a youthful offender adjudication when he was just
But people are resentenced for many, many reasons, and the legislature certainly is presumed to be aware of that. And so as it's putting together, as you say, this broad and carefully crafted system, and seems to have thought of a lot of different things, wouldn't they have thought about using the word resentencing? And if they intended to have it apply to resentencing, they've had plenty of opportunity to do that, notwithstanding our cases.
I think that might actually complicate things, because not all resentencings will reset the clock, not just in terms of Sparber, but in other cases.
Well, is there a point of view that could you say that the legislature has actually not acted on recommendations that the original sentencing date should be used for predicate felony offenders? The way I understand it is the Advisory Committee on Criminal Law and Procedure in 2013 issued a report recommending that the original date be used for predicate felony offenders, not the resentencing date, so long as the original conviction remains intact. It's been before the Senate a number of times and they haven't acted on it. That seems to support your point of view. And that if the legislature has had something in front of it a number of times and hasn't acted on it, I don't think that's dispositive by any means legally. I don't want to overstate it, but it seems to indicate that that there's not support in the legislative body for it, one way or the other.
Counsel, I also just want to clarify. I understood your argument to be a strict statutory construction argument. You're not arguing about policy, which I do view as the DA's argument is. It's not our role to make policy, is it?
I'm not arguing about policy. It
You're
is
arguing about what the statute says on its plain language, what its terms mean, correct?
its plain meaning and the way this court has repeatedly interpreted it, that
But in terms of what might be better policy, what might be better policy if the trigger was the conviction? That's not for this court to decide, correct?
that would be for the legislature
The
to.
legislature's already told us what the purpose of the statute is, right?
Yes. And
But the legislature has never amended it
The
to
leg-
address this issue, regardless of the fact that the case law is very clear.
Correct. The legislature, as many of the judges has pointed out, has had opportunity to amend it and has not. I do also just want to point out that my client received illegally harsh sentences. This is not a minor correction, as the prosecutor seems to contend in their brief. He was twice sentenced to more prison time than he ever should have received. His youthful offender adjudications were really just an empty promise to him, because just shortly after, the same DA's office went into court.
He's already served all those sentences, right?
Yes, he
Okay,
has.
so there's, the only practical benefit to him right now, and I'm not saying that it's right and that it should have happened that way, but and now, as we sit here today, the only practical benefit to him is to reset the clock.
Well, I think that he was entitled to be sentenced in accordance with the law.
No question about that.
And it is unfortunate that
I'm
we
asking about a
couldn't.
practical benefit. There's nothing else that I'm not aware of, is there?
I don't know that I may see the practical benefit differently. I think that he had a right to have those sentences corrected. That was one benefit, and we achieved that when he got his 1993 sentence vacated.
So
He
does the
may-
statute require that if you've been unfortunate enough to have to serve the term you should not have, that you get some practical benefit from a resentencing?
No, but I don't think that can justify punishing him again, even based
There
on
is
the legal
another
sentence.
sentence at issue here, not in this case, right? He has a subsequent sentence to this one that's an issue here, or I might have that wrong.
No, he does have another
So
sentence.
if you were to do this and be successful, the next domino would be the next sentence. So that would be the practical benefit, right? Because he's still serving the 25 to life.
He's serving 25 to life, and depending on what happens here, I would have to assess that and make a decision whether or not we took another step, but that's, not before the court today.
Thank you, counsel.
Thank you.
Counsel, do you care to exercise your rebuttal time?
Just one moment. I just want to point out
Counsel,
that...
why didn't the various district attorneys during these sentencings bring to the court's attention that the enhancements were incorrect?
Why didn't I...
That he was going to be sentenced to more time than he should serve?
Well, he was using a number of aliases, and it could have been that there was confusion as to who he was and whether his priors were youthful offender adjudications or not. The record isn't clear as to why there was that confusion. But I would like to point out that if he did find out, at least in 1990, as to one of the convictions, that he was wrongly sentenced as a predicate. If he had moved any time before 1993 and corrected that sentence and then committed another felony, using my adversary's rule of a resentencing rule, he would still be a predicate. And that seems arbitrary, that it depends on at what point in time the defendant moves for resentencing. Thank you for your time.
Thank you, counsel.